Welcome back to Legalese 123, where we are covering cases across America. Good morning. Good morning. How is everybody doing today? Today is Friday, November the 21st, right? Yes, it is. I hope you're doing well. Sorry, I took yesterday off a little bit, had a few things to do around the house. Plus, it was kind of a slow news day, not much really going on. A lot is heating up in all of our cases, and I will do a Friday case catch up. Currently, right now, Brian Walsh's jury selection has been set. They did settle on 16, so 16 is where it's at. Got this new shirt, and it's very wrinkly, so sorry I'm a little wrinkly today. It's all right. Anyways, I hope you are doing well. I hope that you are enjoying the content that I have going on. If you do, go ahead and like and subscribe. Click to follow me, trying to get as many users as I possibly can because I am scheduled to go to a holiday party in the early December, and I want to get up to 50 subscribers. So I got 25. We're halfway there. I know we can do it. I know we can do it. So please like and subscribe, follow for more content, whatever it is that you need to do. That way it pushes it out to more people, and YouTube knows that I'm here, and you know that I'm here. So thank you again for watching. So, what are we going to talk about today? There is a lot of things going on in the world, but Aaron Spencer, woo, he is popping off left, right, and center. So let's do a little recap on who Aaron Spencer is and tell you what's going on in his case. So let me add this to the stage. If you don't remember, Aaron Spencer versus Arkansas. There was a motion to dismiss on August 26th. That hasn't been dealt with just yet, but we're going to get there. So this is where the prosecution by information or complaint is alternative to a grand jury indictment. Who is Aaron Spencer and what is he being charged with? So Aaron Spencer, this is Michael Fossler. This isn't Aaron Spencer. Aaron Spencer is a 37-year-old who is charged with second-degree murder and firearm enhancement for the death of Michael Fossler, who is 67. Aaron, 37. Fossler, 67. Fossler had been charged with sexual offenses against Spencer's daughter and was out on a $50,000 bond. What? Yes, exactly. So on October 8th, Spencer woke up and found his 14-year-old daughter missing out of her bedroom. The alleged allegations against the sexual misconduct to Fossler was from Aaron's daughter. So he woke up in the middle of the night, found out that she wasn't in her room, heard the dog barking. He went out to go look for her. So it says here that he called 911, but I think that he didn't. So we'll go back and look at that. Again, you have conflicting reports until you get to the motion, so I might have to change that. So he was driving around and just got out of his driveway and found out that Foster was just down the street with him. There was some sort of altercation. Foster was pulled over. Spencer got out of his truck. Foster got out of his truck. Obviously, words were exchanged. Something happened. Spencer shot Fossler. Spencer feels like he was justified in shooting Fossler. That is what is up for discussion. So Fossler had been grooming his daughter and assaulting her multiple times. And like I said, he had 43 counts of sexual assault and internet stalking of a minor. He was in court and released by Judge Barbara Elmore. Judge Barbara Elmore is the same judge in Spencer's case. So, is Spencer justified in his actions? You, as the jury, fact finder in this case, will look at the evidence and you get to determine whether or not you feel that Spencer was justified. There was a gag order in this case. Remember, Judge Elmore said no one can talk about anything because Spencer's wife took to social media and started posting all of the intricacies of his case, and they said no more. It went all the way up to the Arkansas State Supreme Court that his defense lawyer said that this was unconstitutional. And they said, yes, we agree with you. The gag order had been released. It wasn't vacated until June 20th of 2025 this year. So that is when we start getting information about this case. So he motions and stuff are going to be happening. The trial is set for January. So we've got some new information here. So all briefs and replies from October 1st to November 17th are due in court by November 26th, nothing later than December the 3rd. There is a pre-trial conference hearing slated for December the 17th at 9 a.m., and trial is set for January 2026, the 26th through the 30th. But Spencer's attorneys are filing left, right, and center. So the last time we caught up was last week. We have a whole bunch of filings in this case. Let me remove this and let me bring this to you. As you can see, there are a whole bunch of things. So last we left off on the 13th, the 14th, we've got a filing from, it looks like the Commonwealth. They call it the Commonwealth as well. And as you can see, look, they're getting ready. Subpoena, subpoena, subpoena. AT&T. I don't know who all of these other people are, obviously. JS Sheriff. Obviously, you know who that is. Then the judge makes an order for all motions and briefs and replies. More subpoenas, more subpoenas, more subpoenas. 20th, 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 20th. These are all his defense lawyers. So guess what we're going to do? We're going to go through this information. So here we go. Well, the last time we left off was the 13th. So here we are. We're going to go to the 14th here. All right. Let me just move a couple of things around here so I can see how things are going. All right. Let me remove this and let me bring this up. All right. Let me see if I can make this a little bit bigger. There we go. Hopefully you can see it. You can read along with me. Maybe made it a little bit too big. Okay. So this was filed on November the 14th. It's 18 pages. All right. Again, this is the 14th. This is filed from his attorneys. The defense team is just cranking it out. The defendant, Aaron Spencer, by and through his attorneys, Aaron Casanelli and Michael Kaiser, for his reply to state's response to defendant's motion in limine to exclude evidence. Spencer is charged with second-degree murder of Michael Fossler, specifically that Spencer knowingly causing the death of Fossler under circumstances manifesting from extreme indifference to the value of human life. Spencer has asserted the defenses of justification. A person is justified in using deadly physical force upon another person if his person is reasonably believes that the other person is committing or about to commit a felony involving physical force or violence. What do you think about that? Do you think that since Fossler had his daughter, do you think that he was about to commit a crime against her, on her, about her? And do you think that her being a witness in his case, do you think that any unaliving might have happened? I think that might come up. Using or about to use unlawful deadly physical force, imminently endangering the person's life, or imminently about to victimize the person from the continuation of a pattern of domestic abuse. It's just what we just said. Spencer also asserted defense pursuant to Arkansas Code, blah, 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 blah. The state's charges require where are we? Okay, the state charge requires proof beyond a reasonable doubt that Spencer knowingly caused Foster's death by deliberately creating a risk that was practically certain to result in Foster's death. The state must further prove that Spencer did not act under the reasonable belief that Foster was committing or about to commit a felony involving a force of violence against Spencer or Spencer's child, or that Foster was using or about to use unlawful deadly force against Spencer or his child, and that Spencer's conduct was not necessarily as an emergency measure to avoid an imminent public or private injury, and that desirability and urgency of avoiding it outweighed the injury sought to be prevented by the murder statute. Both defenses are to be submitted to the jury if there is any evidence admitted supporting the defense. If so, the court shall charge the jury that any reasonable doubt on the issue requires the defendant to be acquitted. Ooh, very interesting. The chain of events that led to the death of Michael Foster began in July of 2024, though they're going to lay this out, aren't they? July of 2024, when he repeatedly sexually violated Spencer's daughter. Not as the state would have it when Spencer first learned of the horrors of Foster had perpetrated against his child. Oh, they're bringing it back to Foster, which they should, right? The chain of events that resulted in Foster's death definitely began with Foster repeatedly sexually assaulting his then 13 and later 14-year-old child. The chain of events continued with Foster being arrested and released for the crimes, yet continuing his manipulation and deception so he could continue assaulting the child. Until finally someone realized that he had taken her away from her home during the night. When Foster realized that the Spencers realized when Foster realized that the Spencers realized that he had taken control of her that night, he fled with her, refusing to surrender her. Interesting. So remember, we don't know how the events that night unfolded. So now we're getting sort of a glimpse of refusing to surrender her. So was was Spencer communicating with Foster to let her go? How did that unfold? The state's suggestion that the chain of events that resulted in Foster's murder was Spencer looking for information about Foster from a mutual acquaintance is yet another attempt to distract from the chain of events that Michael Foster started and perpetrated until his death. It is yet another deeply concerning indication of its failure to blame the blameworthy, the dangerous pedophile instead of the man who found his daughter under the control of the pedophile. And while the pedophile was facing multiple life sentences and then some for his abuses of her. Ooh. The state also repeatedly manipulates the statements and evidence in its response. For instance, the state says that Spencer told Higginbotham, "Don't call anyone, don't call the police," although that is not precisely what Higginbotham told police shortly after. When he came to speak with Higginbotham, the person through whom Foster accused, sorry, uh, wow, the person whom Foster accessed the child, Spencer actually said, "Don't call anybody." She felt because a family member had been through a sexual assault incident and that the local police department in this jurisdiction had re-victimized her instead of helping her. She explained that Spencer had just learned of the assault from his daughter, and although she did not seem to believe it was true, and he wanted Foster's contact information. The state also admits that the context as to the history of the family connection between Spencer's and Higginbotham and her role in the events that led to Foster's abuse of the child. Uh-oh. So we don't have that information, right? What is the connection between Higginbotham, Foster's daughter, and then it seems like Higginbotham's daughter? Again, this is all going to play out in court or in these motions or in the pretrial conference. We'll see. The state's response that purports to describe the events when officers arrived at Spencer's residence in regard to the grape allegation. In addition to the family's knowledge of local law enforcement failure to assist in a prior child sexual assault investigation, Spencer knew that Fossler had a history in law enforcement and the military. Although the state focuses solely on Spencer's visceral reaction to the learning details of his daughter's repeated rape by Fossler, the reality is that within about 7 minutes, the Spencers agreed that the child would speak to a female officer, and the conversation moved to exchanging information and proceeding with an investigation. Spencer and his wife then spent the next hour and 8 minutes and or more talking with officers about the family history, the situation that led to their daughter interacting with Fossler, and information the child had reported to her mother, while waiting on other officers to respond and filling other time with cordial discussions about everything from the military to animals to movies. Spencer and his wife invited officers to park in the driveway, invited them to sit on the porch, and offered them water. They completed forms and signed paperwork, answered questions, and cooperated with the officers' requests. After waiting nearly an hour, an investigator arrived and explained that another investigator would be assigned to the case, so she would not be speaking to the child that day. She interviewed the Spencers, and they provided her with all the information she requested, including names, contact information, and every detail they knew to that point. They agreed to wait for a detective to contact them the following day to set up an interview with the minor. Spencer thanked the officers for coming, and they cordially departed. It's kind of a far cry from what the prosecution is alleging, right? And that's where we get into these things. We get into these motions and we see what one side is arguing versus another side. And then we get to see how it plays out in court. It's very exciting. The state's attempt to reframe the interaction as one in which Spencer was mainly concerned about the identity of the mandatory reporter and his beliefs in the adequacy of their judicial system is not just false, but completely tone deaf as to the situation the Spencer family suddenly faced and their fierce concern for their child. The state dismisses that Spencer did not refuse the officer's entry or refuse to cooperate or allow his child to cooperate. It certainly doesn't acknowledge the more than an hour he and his wife providing officers with any information they could help put Fossler in jail. While Spencer was worried for his child and angry at his daughter's rapist and the person he felt protected the rapist and who they believed lied to the officers, I'm assuming he's talking about Higginbotham, he was quickly calmed and cooperative. It is difficult to imagine many fathers not feeling and behaving the same way when presented with such horrific and shocking circumstances. What Spencer said then, and he believes still, is that a parent has an absolute right to defend their child against someone who is presenting an imminent danger of harm, like manipulating a minor victim to have sex with him while awaiting trial for numerous sex crimes against her, when the judicial system cannot or will not protect them. And what matters is what actually happened, underlined, not what the state tries to piece together from picking and choosing words spoken months before the event that put the child directly within the control of her rapist. What really happened is that Spencer stood down. He did not attack Fossler when he confirmed his contact information. He went back home to talk to his family. Before they could do so, while preparing their child for the process of reporting this, and that she was about to go through, officers showed up unexpectedly. The next day, they delivered their child for a forensic interview and allowed the criminal process to play out. Let's read this footnote. Spencer and his wife were both concerned that the person who contacted police had lied to them, as they knew she was not a mandatory reporter. They were not told that she had spoken to a third party who is a mandatory reporter and any of the other context of that conversation. They believed she had previously misled them about their child and had concealed the child's victimization at the hands of Fossler, her boyfriend. Oh, the plot thickens. I wondered where this was at. So, her boyfriend, I'm assuming that it's Higginbotham's boyfriend? Or is it the mandatory reporter's boyfriend? Ooh, we're going to find out, won't we? And maybe they were protecting Fossler. Oh my gosh. Ugh, how gross. So if you know that your boyfriend is assaulting a 13 or 14-year-old girl and you willingly go along with this? Oh, no, 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 no. They were upset because it seemed, with the information they had at the time, that she was again deflecting from Fossler's actions by accusing someone in the Spencer family of wrongdoing. Ooh. So they were trying to take the heat away from Fossler by blaming someone in the Spencer family. And when you say blaming somebody in the Spencer family, does that mean that they might have been blaming Aaron, the dad? Oh, this gets good. They did interviews, delivered, and consented to searches of electronics, provided witness information, etc. Fossler was arrested 4 days after the initial meeting at the Spencer's residence. Okay, that statement is Fossler was arrested somewhere else 4 days after the meeting that the police had at the Spencer's residence, because it sounds like they're saying Fossler was arrested at the Spencer's residence. That's how I read it initially. That's not what's happening here. He was seen by a judge, Barbara Elmore, the following day, and it seems an order out of the circuit court was entered imposing a mere $50,000 bond and a generic no contact order prohibiting Fossler's contact with any minor. It was not specific to Spencer's child and did not include any restriction concerning their property or other places the child may be present. Despite the plentiful evidence confirming the use of social media platforms to commit the offenses, he was not restricted in his use of social media. He was not required to report to anyone associated with the court or law enforcement, and neither his internet usage or physical movement were monitored in any way. Interesting. So, again, not a lawyer, don't know the laws in Arkansas, don't know the laws concerning a minor child being assaulted and what the implications are against the accused in reference to, do they get a GPS monitor on them? You would think that they would have a specific no contact order against the victim. I don't know why that's not there. Okay, let's continue. The state's response then begins to describe the early morning of October 8th as if Spencer planned this night of his daughter's being sexually assaulted by the 67-year-old man in order to efficiently and effectively take the law into his own hands. Such insinuation is offensive and absurd, and once again favors the pedophile instead of the victim. The state's own probable cause affidavit for the arrest of Aaron Spencer contradicts much of its description of the morning Fossler died and certainly omits significant information about the events that led to Fossler's death. Okay, so here's the affidavit. He'd been woken up by his dog barking, Spencer, which was uncommon, and went to check on his daughter. The events had occurred early in the year. Aaron Spencer stated that the dog was in his daughter's bedroom, and when he opened the door, the dog continued to act out of character. Aaron Spencer further explained that when he looked closer at what he thought was his daughter's bed, he realized it was actually a stuffed animal with his daughter's hoodie on it. Spencer stated that he became scared of what happened to his daughter and his wife, so his wife called 911. Uh-oh, someone's here. Hold on. Sorry about that. Lots going on today. It was the Avon lady calling. Actually, it was the power company, so I had to pause. Sorry for the sorry for the pause. Uh, there's something going on with the electric company. Anyways, let's continue on. I don't know where we left off, so we'll just go ahead and go right here. So his wife had called 911 to report that she was missing. He then stated that he left his residence and began to search for Michael Fossler and his daughter. Aaron stated that when he arrived at the intersection, he observed the Ford truck belonging to Michael Fossler turned off the highway. Now he's heading east towards his residence. Spencer then stated he turned around, attempted to stop the vehicle by flashing his lights and blowing his vehicle's horn. Spencer stated that he was in fear for his daughter's life and continued to pursue Mr. Fossler on Highway 236. Spencer explained that when he arrived at the intersection, he hit Fossler's vehicle in the rear, causing it to slide off the roadway. Spencer then stated that he exited his vehicle with his firearm in hand and ordered Fossler out of the vehicle and to lay down in the ditch. Spencer stated that he observed his daughter trying to exit the passenger side of the vehicle, but it appeared that Fossler had grabbed her and stopped her from getting out. Spencer then stated that Fossler exited his vehicle and had something in his hand, but didn't know what it was. Spencer stated that Fossler then lunged towards him, saying, "Fuck you!" Spencer stated that he then opened fire on Fossler, emptying his weapon before jumping on top of him and pistol whipping him. Spencer then stated that he got his daughter out of the vehicle, returned to his truck, reloaded his weapon, and called 911. Spencer certainly never told officers that he thought Fossler had entered their home and forced the child into his truck. But when Heather and Aaron Spencer found their daughter's bed empty, they were worried, given that what she had recently been through. They decided Heather would call 911 and he would begin searching the area. They learned about the time from a family member, and Fossler had recently contacted the child. And then they were understandably panicked. They were terrified that Fossler could not only sexually assault their child, but that he would kill or disappear with her, knowing that she was the critical witness to the crimes that would put him in prison for the rest of his life. Like any normal father, Spencer left his wife to the stay of 911 and he went out searching for her. Contrary to the state's suggestions, there was absolutely nothing about him doing this that is unlawful or wrong. In fact, it's exactly what anyone would do. Contrary to the state's misrepresentation in his interview after the shooting, Spencer did not say he was vigilant for Fossler that night. Instead, he explained that he had learned what Fossler looked like, where he lived, and the vehicle that he drove because he was aware that no one was monitoring Fossler. And while he did not watch Fossler, he needed to know if Fossler was nearby. He was worried that without any real barriers in place, Fossler would seek the child out and hurt her again. He explained that he thought that he had seen Fossler driving near the Spencers' home several times, but he was not certain it was Fossler. And if it was, Spencer would not confront him and instead would let the police do their job. But he remained aware of Fossler and aware that no one was watching him, so he explained to the investigators Spencer stayed vigilant for Fossler if he came near their home. Spencer said nothing to investigators about immediately getting back in his truck that night to look for Fossler because he was vigilant for him. He was, however, vigilant in his desire to find his daughter. While Spencer was looking for his daughter, he happened to pass Fossler's truck as it turned onto Highway 31, several miles from where the Spencer's residence is located on that roadway. Spencer saw his child in Fossler's truck. Spencer turned around to follow, and for miles, Spencer honked and flashed his lights, but Fossler sped up, fleeing with the child towards an intersection that would take them out of the area. Before that could happen, Spencer, having been trained in military tactics and maneuvers for disabling vehicles while avoiding significant injuries, pushed Fossler's truck into a driveway. Fossler exited the truck, coming toward Spencer aggressively with something in his hand. Spencer shot him, unloading his clip. Fossler jumped into the ditch and continued to move and curse. And concerned that he may have a weapon, Spencer hit Fossler with the gun to abate any further threat. The state suggests that Spencer had other options that night, including that he could have called 911 when he found Fossler with his daughter. This kind of hindsight is inappropriate and irrelevant. First, and more importantly, there is no law whatsoever in the state of Arkansas that requires a citizen to call 911 in the face of an imminent danger. Arkansas law provides every citizen with the right to protect themselves and their family from the threat of harm. And this is the case. Was he justified in using force to protect his daughter? There is no condition to call 911 first and see if that works out. Second, Heather Spencer had already called 911. Spencer knew that, and unless the sheriff's officers were ignoring the call, they were on their way. If it takes a second 911 call to make it move faster when a child victim witness is pending, why felony case is missing, that is a significant problem for the community. Third, the state's representation about Spencer's phone are simply wrong. Spencer explained to investigators that he could not get his phone unlocked while driving, and also when he was going so fast, he didn't want to have a wreck making a call. Not that he was driving so fast that he could not unlock his phone. The phone records confirm that this is true. He makes no call between the time he located Fossler and the shooting. He spoke with a family member before finding Fossler with his daughter, and while a family member sent him text messages during the interim time, the forensic examination does not establish that he saw those messages at the time she sent them. A critical review of the phone data proves that the times correspond to when a text is sent and received and do not reflect an action to use the phone to read the messages. Once he saved his daughter, his first and only call was to let his wife know that she was safe. He did not reach her. His next call was to 911. The state's assertion Spencer had good reason to believe his daughter had snuck out of the house and had not actually been kidnapped that night is outrageous. It is if the state is portraying this relationship between the child sex assault victim and her abuser is a typical and consensual. How could it be consensual as a 13-year-old minor? The idea that a parent in this situation would reasonably believe that their child was safe in the circumstances is preposterous. Whether or not she was forcibly removed from her home, Spencer and any parent in that circumstances had good reason to believe the child was in danger. This is especially true here when the rapist with control over the child is facing life in prison, and the child is the sole witness. Right. Again, as I stated earlier, if she is the sole witness in this case, what is he doing with her? Even though it matters not how you label it, most reasonable parents would believe this was kidnapping. Footnote 3. The defense believes Foster did legally kidnap the child and does not concede otherwise. However, it is irrelevant whether his conduct technically met the legal definition of kidnapping. Right? The comments also demonstrate a reprehensible blame the victim mentality. The state seems not to understand the victimization of a child by pedophiles like Fossler. The child was 13 years old when Fossler began to groom. Footnote 4. Grooming is a behavior that manipulates and controls the child, as well as those around the child, to perpetrate the sexual abuse of said child. And assaulting her, turning 14 years old shortly before he was arrested in July of 2024. Among many other things, he told her often how much he loved her and manipulated her into believing him and believing that she loved him. A 67-year-old man. even when he hurt her. Unfazed by the dozens of sex crimes he faced for his assaults against her and no contact order prohibiting him from contacting a minor, Fosler continued the pattern of grooming the child so that he can maintain his ability to control her and sexually violate her until the very end. Neither the Spencers nor a reasonable parent would ever consider the circumstances as just a teenager who snuck out of the house. The state seems to be arguing that it was unreasonable for Spencer to believe that Fosler presented a risk of harm to Spencer's 14-year-old daughter if he had persuaded her to sneak out instead of forcing her out of her home. The state also seems to be arguing that Fosler did not commit any crime in persuading his 14-year-old victim to leave the house so that he could pick her up and at minimum have sex with her. But Fosler committed multiple felonies against this child that night. Yet the state seems to insinuate that Fosler did not, in fact, present a danger to the child victim on the night of October 8th, 2024. An insinuation that is also so flabbergasting it is difficult to comprehend. Ooh, it's getting good. We are only on page 11 out of 18. Pause for a minute. I'm going to take a sip of water. All right, let's continue. The state does not, however, offer the last piece of its theory that since the state says Spencer really believed the child willingly joined her rapist that night, he should have called the police a second time rather than follow Fosler's secure the child's safety. The state does not explain how Arkansas law requires any person to refrain from acting in favor of hoping for a police rescue in the face of such danger. The state likewise does not explain how its proposed plan of action would have assured the child's safety. The state does not explain how Arkansas law required Spencer to choose to let Fosler flee with his daughter instead of intervening to protect her. Nothing that Spencer said months prior has any bearing on any of these issues. The only facts of the matter are those that put a child's victim under the sole control of the pedophile who had repeatedly harmed her. Spencer's anger months prior in no way changes the scenario Fosler created that night. Whether Fosler forcibly kidnapped Spencer's 14-year-old daughter and groomed her so that he could continue to abuse her, if not disappear her, the analysis is the same. Either scenario created a legal duty and a legal justification, and certainly a reasonable cause for Spencer to act to protect his child from a sexual predator who refused to leave her alone and who presented a real threat to her safety, both as a victim and witness to his crimes. The suggestion that if Spencer thought his 14-year-old child may have gone willingly with her rapist, Arkansas law requires him to sit back and hope for the best is outrageous. But this is apparently the core of the issue in this case. Thus, it matters not what Spencer left. Sorry, that I transposed the words. Thus, it matters not what Spencer felt or said months prior when he learned of Fosler's grooming and his abuse of his child, because the morning of October 8th, Fosler, by his own choice, posed an imminent threat of harm to his victim, and Spencer had every right and indeed obligation to fight to save her. This is not proper 404B evidence. The issue for trial is not whether Spencer killed Fosler or whether he intended to kill him or planned to kill him or knowingly killed him. Thus, the 404B analysis does not apply. The issue is whether at the time Spencer's action he was reasonable cause to believe that Fosler was committing or about to commit a felony against physical force or violence or was using or about to use unlawful deadly force, and or whether Spencer's conduct was necessary as an emergency measure to avoid imminent injury, where, according to ordinary standards of reasonableness, the desirability and the urgency of avoiding the imminent injury to his daughter and or himself outweighed the injury to Fosler. Ooh. These are complete defenses. The state has to prove otherwise beyond a reasonable doubt in order to convict Spencer. Justification is considered an element of offense, and once raised, must be disproved by the prosecution beyond a reasonable doubt. Spencer did not, as the state insinuates, stalk Fossler and kill him. Spencer did not allow Fossler to kidnap his daughter and grape her so that Spencer could kill him. Those suggestions are absurd. Fossler made the choice to violate the law and the court's order, and to once again endanger his child victim. In fact, he was unrelenting in this regard. Ooh, what did he do? Fossler created and presented a real danger on the morning of October 8th, not Spencer. And therefore, Spencer's initial reaction months prior has no relevance to Spencer's necessary use of force months later. Unless the state is planning to present a theory that Spencer set Fossler up to take his child and assaulting her on the morning of October the 8th so that he could kill Fossler, there is no legitimate 404B issue. The issue for trial is simply whether or not Spencer manifested extreme indifference to the value of human life and whether he may have had reasonable cause to fear for her safety at the time he acted to protect his child. Whether Spencer also hated Fossler or was angry at him after finding about Fossler's horrific crimes does not impact this analysis. If he had reasonable cause to believe that Fossler posed an imminent threat to his child, he is not guilty. Whether or not months prior Spencer had said things in anger about not wanting police assistance or thinking it is BS to suggest, oh my gosh, they actually put this in here. I like this attorney. Or thinking it is BS to suggest that a person could not protect another person for harm without going to prison. The issue for the jury is whether Fossler's actions created reasonable cause for Spencer to act in fear for his client's safety, child safety, not client, child safety, October 8th. Allowing the state to taint the jury with emotional reactions untethered temporarily by the events of October 8th violates Rule 404. So you just kind of like these these writings are for the public, right? Those who are interested, right? So they know that people are reading these. They know that this information's getting out there. Now, whether or not it taints the jury, it depends on whether or not the people in this area are watching TikTok and YouTube, etc. But we appreciate a good brief. It makes us laugh because there's a lot of legalese things in there. Hence the name of my channel, Legalese. Like and subscribe right now. Hurry, hurry, hurry. It gets a little boring after a while. We appreciate a good jab and a good punch in there. All right, let's continue on because that was really good. The state ignores Arkansas Evidence 403. The state completely ignores Arkansas Rules of Evidence 403 in its response. Even if relevant under Rule 404B, evidence may still be excluded under 403. If it is probative value is substantially outweighed by the dangers of unfair prejudice, confusion of the issues, or misleading the jury. That is precisely the purpose and effect of the evidence at issue. Nothing about Spencer's comments in July 2024 shed light on his actions or Fossler's actions on October 8th. Even in July, Spencer did not act upon his frustration or anger. He tried to identify Fossler's residence and his vehicle, and he went home. He thereafter consented to searches and cooperated with investigators. He was, as any parent would be, diligent in trying to keep his daughter safe from Fossler, getting her therapy, limiting her contacts, homeschooling her, etc., and beginning to understand her suffering from the mental manipulation of this man, who is 67, by the way. And if you think this is his first time doing this, Fossler I'm talking about, think again. Typically, rapists have multiple victims. This can't be his first. Fossler prior lived in Indiana, and there is one person in Indiana and she moved to Arkansas, actually happened to be a mile away from Fossler lives, said that he raped her too. I am surprised that not more has come out from this. Stay tuned because I have a feeling that there's going to be an explosion of more information. He was also, as any parent would be, diligent in learning information to identify the person who targeted and hurt his child so that his family would be aware if this man targeted her again. It is only when Fossler actually took his daughter from her home that Fossler presented an imminent danger to her that justified Spencer's action to protect his daughter. As it turns out, unbeknownst to the Spencer, Fossler had been communicating with his child since about a month after his release on bond. With no bond condition or supervision dissuading him, he continued engaging with her and others on social media platforms and had directed the child as to keeping the communications secret. No. He had picked her up on 3 occasions between his release from custody and the night of October 7th without anybody knowing. How and why? How did that happen? On this final occasion, Fossler spent about 4 days or so persuading her to leave her house and go with him for the express purpose of committing criminal sexual acts with her. She left the house around midnight, and Fossler picked her up near the Spencers' home. Fossler then drove her to his home in Cabot, sexually abused her, and was driving her back near her home. Oh. Oh. Oh, hang on. Oh, hang on. We didn't know this. New information. Okay, let's go back. On this final occasion, Fossler spent about 4 days or so persuading her to leave the house and go with him for the express purpose of committing criminal sexual acts with her. She left the house around midnight. Fossler picked her up near the Spencers' home. Fossler then drove her to his home in Cabot, abused her, and was driving her back near her home when Spencer encountered them. Spencer had no idea that Fossler had continued to communicate with his child after the arrest and was certainly had no idea that he continued to victimize her. Oh my gosh. Oh. If this doesn't like put a like the hairs on your arm stand up or like give you like the gross icky icks, it should. Like any parent, Fossler went looking for his daughter when she was found to be missing. Once he saw Fossler was in her custody, Fossler made it clear he would not peacefully let her go. Like any parent in that moment, whether or not 14-year-old child recognized the danger, her parents believed she was in danger in the custody of her rapist and that Fossler had every reason to harm her to avoid life in prison. Fossler certainly did not, by his own behavior that night, indicate otherwise. To permit the state to try this as a case of premeditation or intentional murder, as if there was no legitimate question as to the risk posed to the child victim that night, or as if Spencer somehow knew and planned to kill Fossler and allowed Fossler to harm his daughter again to do it, would be prejudicial error, allowing the state to try Spencer for his reaction to the initial disclosure of abuse and the gory details, and not the circumstances and actions that led Fossler's death. There's absolutely no evidence to suggest that Spencer knew Fossler would take control of the child and create a situation in which Spencer had to defend her and to allow the state to suggest so is highly prejudicial and misleading. Spencer's comments in July are irrelevant to the issues in the case and threaten to continue the issues for the jury consideration and mislead them into fundamental misunderstanding of the law and how the facts apply to it. All right, we are on page 15. We have 3 more to go. Hold, please. All right, let's continue. Conclusion. Allowing the state to suggest that Spencer's actions to protect his child from her rapist were not motivated by concern for her safety at all, but instead by panic, anger, fear, or frustration. He expressed 3 months earlier would be prejudicial in error. His comments upon learning that his child had been sexually abused do not make it more or less likely that he reasonably believed she faced danger when Fossler had her in his control and refused to release her. Any suggestion that those comments demonstrate an intention or plan to act months later, when Fossler actually had control of the child for purposes in engaging in criminal acts, is illogical, unsupported by the circumstances, and would mislead the jury. The events of October 8th, Fossler's actions and Spencer's response to them, are the relevant facts the jury must consider. The state should not be permitted to divert attention from those facts by implying that Spencer responded poorly or displayed bad character when he first learned of his daughter's victimization. Spencer did nothing to harm Fossler at the time, and instead he and his family cooperated with authorities prosecuting Fossler. It was not until Fossler put Spencer's child in danger again that Spencer acted to protect her. There was nothing vigilant about There's nothing vigilante about Spencer's action to protect his child on October 8th. He acted in response to an obvious threat of harm. Although the state apparently disagrees with Spencer as to whether or not Arkansas law protects a person from prosecution for protecting himself or his family when confronted by the imminent danger that is uncontrolled by law enforcement or the judicial system, that decision is for the jury. Wherefore, the defendant, Aaron Spencer, asks the court to grant the defendant's motion in limine or for any other relief the court finds appropriate. Respectfully submitted, Aaron Casanelli, Michael Kaiser. And there's the affidavit for the arrest. All right. Woo! Oh, that was a lot of information just in those 18 pages, right? So again, that is where this gets interesting, right? So you're watching court scenes and you're watching court happen, but there's a lot of things that happen before you see it on TV. These are motions in limine, motions that go back and forth. The prosecution alleges one thing, the defense comes back and says, no, judge, something else. A lot of things have to be supported by case law, right? The case law says this, and then you argue your point. The case law says this, argue your point. And then the judge gets it in front of her. Sometimes she reads the papers, and sometimes she will rule on the papers right away. Sometimes you're allowed to get up and argue your point again. Typically, your papers are supposed to have what your argument is. You have to be very specific and very diligent in your papers before you hand them to the judge. There have been a couple of cases where people are just like, nah, judge, and they just argue their case. There's no factual basis. There's no legal cases and stuff that support their argument. And the judge is like, well, what am I supposed to do? You have no legal basis, no legal argument here to support your theory or your cause. So judges get frustrated when you do that. So that was what was, let's stop that. That was what was on the 17th. So let's go back and let's look at let's go look at this docket again. Oh, I have to share it. Here we go. Da, 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 da. Oh, here it is. Da, da, da. What side am I on? Da, 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 da. Here it is. Okay, so that was the 14th, right? Let's see what we have next. So the last stream I did was on the 13th. So here we are on the 14th. I don't know if my cursor can show you that. This is what we just read. Again, they subpoena. They're getting ready to call all of these people to trial, giving them a head up. So on the 20th, There is a brief in support of amended motion to dismiss felony information on the Fifth Amendment grounds. Let's read what this has to say. Oh boy. All right. We're going to remove that. Now we're going to go ahead and we're going to add this one. Okay. This one is this one. Add to the stage. All right, here we go. Brief in support of amended motion to dismiss felony information on the Fifth Amendment grounds. Requiring a grand jury for felony charges is deeply rooted in history and tradition because it protects the fundamental principles and liberty and justice for all, right? You said it with me, right? Justice for all. The grand jury clause of the Fifth Amendment in the Constitution provides no person shall be held to answer for a capital or otherwise infamous crime unless or a presentment indictment of a grand jury. Oh, okay. So I'm not going to read all of this. This goes to Arkansas has a weird thing. I went over it in the beginning. Arkansas has a weird thing. Let's see. Okay, I can share this. Okay. So Arkansas has this weird thing we talked about. This is still their motion to dismiss. I think they're continuing this. Arkansas has a code which permits the prosecution by information or complaint as an alternative to a grand jury indictment. What that means is the prosecutor is the one that can go ahead and put this case forward to a jury, to a trial, to a judge, right? Typically, you have to present evidence to a grand jury and get a grand jury indictment. And in Arkansas, they don't have to do that. So the defense continues to argue this case that it should be put forth to a grand jury. So we're going to just look at this really quickly. I'm not going to go through this. It's the same. It's the same thing. Again, none of this has been argued in front of the judge. So let's just get down to like where that has the conclusion. The conclusion is the guts of everything. This, when we talk about case law, you see all of this is case law, case law, case law, case law. It is really, really good. Okay. Conclusion. An individual's Fifth Amendment right to be free from serious criminal charges, except those charged by the indictment of a grand jury, again, no grand jury here, shields not only this defendant, but all of us from the exact, okay. Not only this defendant, but all of us from exactly the sort of deprivations of liberty without due process that the farmer sought to prevent. Doo, 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 doo. Such a grand cause, right? Rather than continuing down the path of affirming a prosecutor's purported power, even when it contravenes the express will of a grand jury to unilaterally charge people with capital crimes and other serious felonies, this court should look at to the language and the intent of both relevant constitutions. With due consideration to the development of the constitutional law in this area since 1884, back to the Magna Carta, it should find that the felony information in this case violates the Fifth Amendment's grand jury clause as incorporated by the 14th Amendment. All right. That's some good lawyering right there. Mr. Spencer, you're getting your money's worth. All right, let's go back to this. All right. So, we just looked at this one from the 20th. I'm thinking this is okay, brief support and amended motion for discovery. Let's look at this one. Okay, let's bring this one to the stage. Do, 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 do. All right. Let's make this a little bit bigger. All right. So they're asking for discovery, right? Discovery means they're asking for information, evidence, etc., that the state needs to provide to the defense so that the defense can amply and judiciously uh, defend their client, right? Advocate for their client, right? And so the prosecution has to turn over everything. If you go back to the Karen Read case, we are still learning that the defense hasn't turned over all of the things that they were supposed to do. And in the Aiden Carney case, they aren't turning over things that they're supposed to turn over as well. I guess Massachusetts is the upside down, crazy, cuckoo world where, you don't need this stinking evidence to defend yourself. So here is where the defense is asking for more discovery, and all discovery should be turned over by a specific date that the judge states. And if it isn't, and they find out later, there could be consequences. What those consequences are could be that evidence doesn't get put in. It could be that in the Miles King case, he was being held without bail. He then got out on bail, so he's out on bail now because they withheld discovery from him. Again, Massachusetts, upside down cuckoo world. All right, let's continue. So the defendant is requesting materials, names and addresses of persons the prosecuting attorneys intend to call. Everybody gets a witness list. Any written recorded statements, report statements of experts, books, papers, documents, things that they're going to use at the trial, any record of prior criminal convictions of the person prosecuting. I think they're probably wanting to get Fossler's stuff. Electronic surveillance of the defendant's premises or conversation to which the defendant was a party. That's where they had like the body cam worn stuff. Okay. The prosecuting attorney should disclose whether any requests for or offers of immunity, leniency, sentence, or charge concessions and or inducements have been made by or to any other co-defendants, potentially witnesses or informants. So that's interesting, right? So if there are any other people that are involved with this and they said, oh, tell us all that you know, and you're not going to be charged with a crime, or they might have been charged with something and they say, oh, we're going to go ahead and just give you 2 years in jail instead of 6 years in jail for in exchange for your testimony. So did somebody else get charged in reference to this case? That's very interesting because remember, Fossler's girlfriend is involved somehow. Did she knowingly know that Fossler was abusing his child? That is a very, very good question. If you're thinking it, I'm thinking it, we're aligned. All right. So basically they want everything, which is rightfully so. But sometimes you have to put it in writing. You have to specifically say you want XYZ, because then later on the prosecution can say, well, they didn't ask for it, judge. They did that in the Karen Read case. United said that they wanted all video evidence, but he wasn't specific enough. And the judge was like, well, you weren't specific enough. How specific do you have to be? Anyways, so that was that latest one. Let's go and see what the next one is. What is the next one? All right, let's add to the stage. All right, so we did more amended for discovery. All right, it's just giving just sort of like blanket stuff. We want all the discovery. All right. Amended motion to dismiss felony information on Fifth Amendment grounds. Let's read this one. It's very short. So we're going to remove this one. We're going to add this one. Add it. Oh, well, you got to add it, dummy. All right. Here we go. Let's make this one a little bit bigger. All right. Comes now the defendant Aaron Spencer by and through his attorneys and for his motion to dismiss this criminal case under the Fifth Amendment to the United States. The court should dismiss this felony information because it violates the grand jury requirement of the Fifth Amendment to the United States Constitution. Stare decisis is not licensed for the state to pursue such an unconstitutional course of conduct. Well, we're going to have to look that word up. Hang on. Hold, please. This is really interesting because that is some language. Stare decisis. All right, what does that say? A legal principle of determining points in litigation according to precedent. Stare decisis is the legal doctrine the courts should follow precedent set by prior decisions when ruling on similar cases to ensure consistency, stability, and predictability in the law. It is a Latin phrase meaning to stand by things decided and operates in two ways. Vertical stare decisis, where the lower courts must follow the precedents of higher courts within the same jurisdiction, and horizontal stare decisis, where a court generally follows its own previous rulings. Now, I could have mispronounced that. Sorry. I'm not up on my Latin. Following the Supreme Court's incorporation of the Sixth Amendment jury unanimity requirements, Ramos versus Louisiana, nearly every core criminal procedure protection in the Bill of Rights has been incorporated to the states through the Due Process Clause of the 14th Amendment. The court's incorporation doctrine under the 14th Amendment ensures that the minimum content of due process is not subject to erosion by state legislatures. The last unincorporated criminal procedure right is the Fifth Amendment's grand jury clause, where to require states to comply strictly with the grand jury clause was last considered. Hurtado versus California. That precedent, if read today in light of recent decisions and historical precedent, cannot justify a process that strips criminal defendants of a foundation procedural protection. Accordingly, Spencer respectfully requests dismissal of the felony information in this case. Dun 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 dun. Signed, Michael Q. Kaiser. Da 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 da. Okay, so they've had several grounds that they want to go ahead and get motions to dismiss. All right, that is the last and the latest information that we have in the Aaron Spencer case. So, as I stated, this is Fossler. We already went over what is going on with him. He is 67 years old, and he was charged with 47 counts of sexual offenses and other things against Spencer's daughter. Oh boy. That was in July of 2024. Remember, this encounter with Spencer and Fossler happened in October. So, what did we glean from this? We got some more information. Let's just go through this really quickly. There is a pre-trial conference set for December 17th. Hello, Reed. At 9 a.m. We do not know if this is going to be televised. This, again, is in a very small county in Lonoke, Arkansas, so we don't know if it's going to be televised. You might have to have what's called boots on the ground. There's a trial date set for January 26th and the 30th. Will Judge Barbara Elmore go ahead and dismiss these charges based upon what the defense is alleging? If not, and she's going to go ahead and let this go to trial, how is this going to play out? What we gleaned from these motions, and see, it's important to read these motions because you get a full sense of this case. We now know there is another party involved. Who is that other party? Could it be Mrs. Higginbotham, or it could be the other person? I don't know specifically. I don't read the rumors, innuendos, and suggestions from other things. I'm not actively seeking out things. I like to read the court papers and glean information from that. There's another person involved. She was the girlfriend of Fossler. How old is she? What did she know? Is she culpable in any way, shape, or form in knowing that he had committed these atrocities against Spencer's daughter? Stay tuned to find out more on this case. If you like this case or you're interested in more cases, like and subscribe. I got 26 subscribers. Let's go. We want to get to 50 by the end of this month. Hope you have a great weekend. Stay tuned. I'm going to have a case update today. And also Karen Reed is back in court today. What did we glean from her civil case? Stay tuned for more information. Bye. Thanks for watching Legalese 123. If you like what you saw, please like and subscribe for more content.